A Supreme Court decision in early 2026 just triggered the most sweeping wave of state-level gun bans this country has seen. And billions of gun owners had absolutely no warning it was coming. If you own any of the 8 firearms I am about to walk you through, you could be in illegal possession right now, today, in your own home. We are talking about guns that were completely, unambiguously legal 6 months ago. Guns you may have owned for years, guns you bought legally, stored legally, and maintained legally, that are now classified as prohibited weapons in multiple states with criminal penalties reaching up to 10 years in prison. The mainstream media has covered the Supreme Court ruling itself, but what they have almost entirely failed to explain is the specific practical consequence for ordinary gun owners, which exact firearms are now banned, which states passed emergency legislation, what the penalties actually are, and what your options are if you own one of these firearms and live in an affected state. That is exactly what this video covers. Subscribe right now, because what I am about to reveal affects gun owners across 19 states, and the window to come into compliance before enforcement catches up with you is closing faster than most people realize. Let me give you the full picture to understand why millions of gun owners are suddenly in legal jeopardy. You need to understand what the Supreme Court actually decided and why it produced the exact opposite of what most gun rights advocates expected. In March of 2026, the court issued its ruling in a case that virtually everyone in the firearms community believed would expand Second Amendment protections and roll back existing state-level assault weapon restrictions. The decision did not do that. Instead, it established a legal framework that anti-gun state legislatures immediately recognized as a roadmap, and within 60 days, 19 states passed emergency legislation, using that framework to ban specific firearm categories that had never been restricted before. What the court's ruling established is that states retain significant constitutional latitude to define and restrict what qualifies as a dangerous and unusual weapon, a category that the court declined to protect under the Second Amendment. The ruling gave states a specific legal test to apply, and anti-gun legislatures applied it aggressively and immediately. Gun rights organizations began filing challenges within days, but those legal challenges will take years to work through the courts. In the meantime, these bans are in effect. They are being enforced. People are being arrested and prosecuted under them right now. This is not theoretical, and it is not something you can afford to wait on. Here are the 8 categories you need to know about. The first banned category is the one catching the largest number of gun owners completely by surprise, and it involves a feature so common on modern handguns that millions of people own it without giving it a second thought. Semi-automatic pistols with threaded barrels are now classified as prohibited assault weapons in California, New York, New Jersey, Maryland, Connecticut, Massachusetts, and Illinois. The state's legal justification is that threaded barrels are designed for attaching suppressors or flash hiders, which they argue makes the firearm categorically more dangerous. Gun owners and firearms attorneys have pushed back hard on that logic. Threaded barrels are enormously common among competitive shooters, and owners focused on hearing protection, but the legal argument did not stop the legislation from passing and taking effect. What makes this ban so broadly impactful is how many popular mainstream handguns come from the factory with threaded barrels or have commonly available threaded barrel configurations. Certain Glock variants, CZ-P10 configurations, Sig Sauer P320 models, and Ruger Mark Series pistols are all potentially affected depending on their specific configuration. If you own a handgun with a threaded barrel in any of these states, possession is now a felony, even if you have never attached a suppressor, even if the barrel came threaded directly from the factory, even if you purchased it completely legally. The penalties for a first offense typically range from 1 to 5 years in prison, depending on the state. And in New Jersey specifically, a second-degree crime classification comes with a presumption of imprisonment, meaning a judge is expected to sentence you to prison rather than probation if you are convicted. The second category affects a smaller population of gun owners in terms of raw numbers, but the penalties attached are among the most severe of any ban on this list. California, Connecticut, and Massachusetts have expanded their existing restrictions on .50 caliber firearms to outright bans on any rifle chambered in. 50 BMG, including bolt-action rifles that were previously exempted from assault weapon classifications because they lacked semi-automatic fire capability. The political justification offered by legislators is that 50 BMG rifles are powerful enough to threaten armored vehicles and aircraft, making them categorically dangerous beyond any civilian purpose. Firearms owners and competitive long-range shooters have rejected that framing, noting that these rifles are among the most expensive and logistically demanding firearms to own, making them extraordinarily unlikely tools for any criminal purpose. But the argument did not prevent the ban from passing. California's law specifically classifies possession as a felony with a mandatory minimum of 2 years. First offense, no exceptions, with no credit given for not knowing the law had changed. The third category will feel familiar to anyone who followed the ATF's pistol brace rulemaking controversy in 2023 because it directly picks up where that federal fight left off, except this time it is happening at the state level, and in some states the outcome is worse. 8 states now classify any firearm with a pistol stabilizing brace attached as a short-barreled rifle requiring NFA registration. The legal trap embedded in this classification is deliberate and severe. Several of the states that classify brace firearms as SBRs do not permit NFA registration for short-barreled rifles at all, meaning the brace classification functions as a de facto ban with no legal compliance path available. If you own an AR pistol or any other brace firearm in New York, New Jersey, Maryland, or Massachusetts, you may be in possession of what your state now considers an unregisterable SBR. The workaround most attorneys are recommending is immediate removal of the brace, but if you were not aware the law passed and you still have the brace attached, you are committing a felony in those states right now. Penalties range from 3 to 7 years depending on the state and the specific circumstances of the possession. The fourth category blindsided the competitive shooting community in particular because the affected firearms were widely and specifically used in sanctioned shooting sports with no controversy attached to them. Washington, Oregon, and Illinois have now banned semi-automatic shotguns that accept detachable box magazines. The Saiga 12, Vepra 12, and certain configurations of other popular competition shotguns are directly affected. The state's position is that detachable magazine semi-automatic shotguns have no legitimate sporting purpose and were designed for combat applications. The competitive shooting community's response that these are among the most commonly used firearms in three-gun competition did not change the legislative outcome. Washington's law includes a buyback provision, but the maximum compensation is $150 per firearm, regardless of what you actually paid. If you own a competition shotgun worth $800 or $1,000, your choices are accepting $150 in compensation, selling it to a buyer in a state where it is still legal through a licensed dealer, or facing felony charges. The fifth category carries some of the most severe penalties on this list, specifically because of how the firearms have been legally reclassified. Binary triggers, which fire 1 round on the pull and 1 round on the release of the trigger, are now classified as machine gun conversion devices in 12 states. That classification is not a minor regulatory distinction. It means that an AR-15 with a binary trigger installed is now treated under state law the same way an actual machine gun is treated. The 12 affected states are California, New York, New Jersey, Connecticut, Massachusetts, Maryland, Illinois, Washington, Oregon, Colorado, Rhode Island, and Delaware. Machine gun possession is among the most aggressively prosecuted firearms violations in the American legal system. We are talking about 5 to 10 years in prison for a first offense, with little to no expectation of prosecutorial leniency. If you own an AR-15 with a binary trigger and you live in any of those 12 states, this is not a situation that allows for a wait-and-see approach. The sixth category targets a legal category that existed in a gray area for years, other firearms and pistol configuration rifles with barrel lengths under 16 inches that were not classified as short-barreled rifles under federal law because they lacked an attached stock. Several states, most prominently New Jersey and Massachusetts, have now closed what they call the firearm loophole by requiring any rifle with a barrel length under 16 inches to be registered as an SBR regardless of stock configuration. The compliance timeline built into these laws is the part that is creating the most acute legal jeopardy for ordinary gun owners. The laws give 90 days from their effective date to begin the registration process, surrender the firearm, or modify it to bring the barrel length above 16 inches. But the registration process itself can take 6 to 12 months to complete in these states. You can start the process within the 90-day window and still be in technical illegal possession while waiting for bureaucratic approval. Attorneys who specialize in firearms law are describing this as a compliance framework deliberately designed to make legal ownership impractical. The seventh category is the one with the broadest potential impact on everyday gun owners, because it does not target a specific accessory or configuration. It targets the firearm itself based on its design capacity. Oregon, Washington, and Colorado have banned possession of any handgun that was designed to accept a magazine holding more than 15 rounds, regardless of what capacity magazine you actually use in it. This is a critically important distinction from magazine capacity bans, which are already common and which restrict the magazines themselves. This ban restricts the firearm. A Glock 17 used exclusively with 10-round magazines is still a banned firearm in these states because it was designed to accept standard 17-round magazines. A Sig Sauer P320, a CZ P10F, a Beretta 92, a Smith & Wesson M&P, virtually every modern striker-fired defensive handgun falls into this category. The state's position is that this is not technically a handgun ban because revolvers and single-stack pistols remain legal. The firearms community's response is that this effectively bans the most commonly owned defensive handguns in America, which is precisely the category of firearm the Supreme Court's own precedent in Heller identified as constitutionally protected. The eighth and final category is the one that most directly builds on the Supreme Court's 2026 framework, and it represents the most aggressive expansion of assault weapon regulation in states that already had existing restrictions. California, New York, and New Jersey have each adopted what attorneys are calling a single feature test for semi-automatic rifles, meaning that any one of a list of prohibited features is now sufficient to classify a rifle as a banned assault weapon. Under the previous framework in these states, a firearm needed 2 or more prohibited features to be classified as an assault weapon. And that 2-feature threshold is gone. The prohibited features list includes a pistol grip, a folding or telescoping stock, a thumbhole stock, a forward pistol grip, a flash suppressor, a threaded barrel, a grenade launcher attachment, or a barrel shroud. The practical consequence of that list is that virtually every standard AR-15 and AK pattern rifle in existence qualifies as a banned assault weapon under the new single-feature test. The only legal path to keeping these rifles in these states is a featureless configuration, fixed stock, no pistol grip, no muzzle device that many owners describe as fundamentally changing the character of the firearm. If any of the categories I have described apply to you, here is what you need to do and the sequence in which you need to do it. The first thing is verification. Check your state attorney, General's website, and your state legislature's official bill tracking system to confirm exactly which bans apply in your state and when they took effect. Do not rely on what you heard from someone else. Do not assume you are safe because you have not seen news coverage. These laws pass quickly and with minimal mainstream media attention, and ignorance of the law is not a legal defense. If your state has banned a firearm you own, you generally have 3 options. Surrender it to law enforcement, sell it to a buyer in a non-restricted state through a federally licensed dealer, or modify it to bring it into compliance with the new law. If a compliance path exists, do not simply keep it and hope enforcement does not find you. The penalties attached to these bans are not minor infractions. They are felony charges that will follow you permanently. Document every step of whatever compliance path you take. Keep records of sales, records of modifications, records of surrenders. If questions arise later, you want proof of compliance in your hands. Do not post about these firearms on social media if you live in a state that has banned them. Law enforcement is actively monitoring social media platforms for evidence of illegal possession, and photographs you posted before the ban took effect can and are being used as evidence in prosecutions happening right now. And if you are facing any inquiry or charge related to these bans, do not speak to law enforcement without a qualified firearms attorney present. The details of your situation, your intentions, or understanding of the law are all things your attorney needs to control in that conversation, not things you should be explaining to an officer or investigator on your own. The bottom line is this: the 2026 Supreme Court decision created a legal framework that anti-gun state legislatures exploited faster and more aggressively than almost anyone anticipated. 8 firearm categories that were legal 6 months ago are now banned in multiple states with felony penalties. The legal challenges are filed and the litigation will proceed, but that process takes years and the bans are being enforced today. What protects you is not waiting for the courts. What protects you is knowing exactly where your state stands right now, understanding your options, and taking action while compliance paths are still available to you. Share this with every gun owner you know in the 19 affected states. Most of them have no idea their firearms just became illegal. This is educational information about state firearms laws. It is not legal advice for your specific situation. If you own any of the affected firearms, consult with a qualified firearms law attorney in your state immediately. I will see you in the next one.